All rise. The 14A District Court for County of Washington, State of Michigan is now in session. All those applications for the court are near. Judge J. Simpson presiding.
You may be seated.
Right away, this case is being framed like a simple landlord-tenant dispute. But listen closely, because Judge Simpson is about to walk into something much messier than unpaid rent. On paper, this should be basic. Landlord says tenant owes money, tenant either agrees or disputes the number, and the court decides what happens next. But courtroom cases are rarely that clean, especially when personal relationships, family drama, unpaid rent, and legal paperwork all crash into each other at the same time. What makes this one dangerous is that one wrong filing can change everything. Not just the outcome, but the tenant's rights, the landlord's options, and whether the judge can even give the landlord what he wants. So as this starts, watch Judge Simpson closely. He is not just listening to who sounds emotional. He is checking the math, the lease, the timeline, and the legal category of the case.
Court does call the case of Meta versus Jackson. Mr. Meta, actually, you're on this side, Mr. Jackson. All right. The landlord-tenant matter. And Mr. Meta, how much is it you claim he owes?
Claimed now the present claim is $3,025.
$3,025?
Yes.
Mr. Jackson, how much do you think you owe?
4 months.
4 months?
Yeah.
Which, how much is that per month?
600.
It's 600 a month. So you think you owe 2,400? Okay. So there's basically a $625 difference between the two of you.
$5 per month is just for 5 months. From December to this month.
Okay. He wants to show me something. What is that?
Ledger you said.
Show it to Mr. Jackson.
I remember seeing this paper before.
Pardon? Right. Yeah. I don't even know what it is because I haven't seen it myself. So let me look at it. Yeah. And then we'll talk about it.
This is the first important slowdown. Judge Simpson is not rushing into a ruling just because one side walked in with paperwork. He is doing what a good judge has to do. Pause, inspect the document, and make sure everyone understands what is actually being used in court. And this matters because landlord-tenant cases are extremely technical. A number written on paper is not automatically proof. A lease is not automatically enough. A notice is not automatically valid. Every piece has to match the legal claim being made. The funny part is, everyone in the room seems ready to argue feelings, promises, and frustration, while Simpson is still on step 1. What am I even looking at? That tells you the case may already be shaky. And here is the question. If the judge has to decode your own filing before he can rule, are you really ready to win?
So is your rent 605 or 600?
605.
605.
Is it?
Yeah.
Okay. Okay. All right. So hold on. When did you move in? Was it the 15th of or halfway through October?
I think is either November around that time.
Okay. Okay, so Mr. Jackson, let me ask you this. I mean, it really won't matter. You must have moved in October only because he's got the security deposit on it and said they received 300. So that sounds to me like it was mid-October or somewhere around there. All right. So November of 2022, you paid 605. Okay. Did you make a payment in December?
No, I did make a payment in December, but
like I
said, the agreement was really why, in my opinion, why I think we're here, because first he used to like talk to my mom, like they used to be like girlfriend, boyfriend. And then until they stopped talking, and that's when everything went left. We had an agreement about everything, but until they stopped talking, that's when everything just went left, really.
You telling me that story, it went left. So your mom and Mr. Mehta?
Yeah.
Now the case takes a sharp turn. The tenant is not just saying, "I did not pay." He is giving a reason why the relationship between the parties collapsed. According to him, the landlord was talking to his mother, and when that personal connection broke down, everything changed. Legally, that does not erase rent, but dramatically, it explains why this case suddenly feels less like a clean eviction and more like a personal fallout wearing a legal costume. Judge Simpson now has two tracks in front of him, the money track and the motive track. The money track asks, how much rent is unpaid? The motive track asks, why is this landlord really trying to remove him? And that distinction matters because courts do not exist to settle emotional revenge. If the landlord has a legal claim, he must file the correct legal claim. Personal frustration cannot substitute for procedure.
Okay, so what did you think the agreement was? Well, I guess this other relationship was going on.
But the agreement was, when I talked to him, well, he knew that I had to come here. I didn't, have a job. I had to find a job and everything. And we talked about when my taxes came, that was when I was supposed to pay them, but then I had to amend my taxes, so that took the process even longer. So that's how we're here.
Okay, so you say when you came here, where'd you go?
Kalamazoo.
Okay. Is there a lease at all?
Yes, the lease I gave you. Want it?
Yeah. We'll show that to Mr. Jackson, make sure it's, is that
He has the copy. He signed it.
Yeah, this is the one.
that's the lease? Okay. So, Mr. Jackson, there wasn't a payment. I mean, is it correct you didn't make a payment in December, January, February, March, April?
Yeah.
Okay, all right.
This is where Judge Simpson gets the math under control. December, January, February, March, April. That is 5 months. At $605 a month, the landlord's number starts making sense. The tenant thought the total was closer to 4 months, but once Simpson lays out the calendar, the disagreement shrinks. This is exactly why judges walk through the numbers out loud. It removes confusion. It forces both sides to confront the timeline, and it turns emotional argument into arithmetic. But here is the twist. Proving unpaid rent is only half the battle. Even if the tenant owes the money, the landlord still has to file the right type of case. That is the legal trap coming next. The landlord may be right about the debt and still wrong about the remedy. That is what makes this hearing so frustrating and honestly, so entertaining.
So what I come up with, well, you tell me you owe 24. If I count 5 months out, I get 30.25 that you owe. Because I have 5 months. I have December, January, February, March, April. That makes sense to you?
Yes, sir.
All right. Because you gave him a notice to terminate his lease, but he still has a lease. He has the ability to redeem the property. Who are you?
I'm son-in-law. His son-in-law. I stay with him in Kalamazoo. I'm in Kalamazoo now. I'm not here.
Okay, you keep raising your hand. What do you want to tell me?
He has been making false promises since December. I will pay, and then he don't, and then he come up with another excuse. And he has been,
Okay, I'm just saying this. Let's assume everything you say is true. Okay? You filed the wrong type of case.
I filed for his eviction. I don't want money from him. Let him go.
But you just said if he paid, he could stay.
He could have paid, but he didn't pay. If he would have paid, he would have up-to-date payment.
It doesn't work that way. It doesn't work that way.
There it is. Judge Simpson finally says the quiet part out loud. It doesn't work that way. The landlord wants the tenant out, but also admits that if the tenant had paid, he could have stayed. That matters because those are two different legal worlds. If this is about unpaid rent, the tenant usually has redemption rights, meaning he may get a chance to pay and avoid eviction. But if the landlord files a termination case, that suggests the lease is being ended for a different reason, not simply rent. You cannot mix and match remedies like courtroom buffet food. Simpson is calling out the contradiction directly. You want money, but you filed like you want termination. You say he can stay if he pays, but your paperwork says something else. So what is the real goal here? Rent recovery or getting him out no matter what?
Let him pay them.
Your Honor, he will not pay. He'll just,
Okay, you guys can keep trying to shove that round peg into the square hole. I'm just telling you, you filed a termination case. You're telling me that if he had paid, he could stay. Right?
I could have been good for him if he would.
Okay. The problem is, in this type of case, he doesn't have that option.
My option is no money. Let him go for it.
Yeah, it doesn't work that way.
Tell me now, I am a senior citizen, 83 now, 83, and I'm making only $400 social security. And I was depending mainly on the rent, and which is not coming.
Okay. I feel bad for you. The problem is, you got to do things the right way. So why did it take you so long to get to the court if you wanted him out? Because according to you, he hasn't paid rent since December.
Yes,
You don't file anything till March.
first time it was wrong. You said my notice was wrong, so I had to wait.
Yeah, it's wrong again. If what you're claiming, he's got a lease.
Yes,
On what grounds are you terminating the lease?
it's non-payment basically.
Then you have to file a non-payment case.
I don't want the payment from him. Let him get out from this place. I want my house back so that I might be able to sell it or maybe get somebody.
Mr. Mehta, you don't get to make the law.
This moment is brutal because Judge Simpson cuts straight through the emotional appeal. The landlord is elderly, says he needs income, and wants his property back. That sounds sympathetic. But sympathy does not rewrite lease law. Simpson's point is simple. You do not get to make the law just because your situation is difficult. If there is a one-year lease, then the landlord must use the correct legal grounds to end it. If the issue is non-payment, file non-payment. If the issue is a lease violation, identify the violation. But you cannot just say, I want my house back, and expect the court to erase the tenant's rights. That is the harsh reality of civil court. A judge can feel bad for you and still rule against your paperwork. And this is where the case starts slipping away from the landlord fast.
There are different types of cases you can file. You can file a 30-day claiming that that you're terminating his lease, but you have to have grounds for what you're doing that when he's got a one-year lease. Or you can say it's non-payment. And if it's non-payment, then you're going to say what he owes. The judgment is going to indicate that he has a certain period in time at which to pay. That's not what you did. And it almost seems, I mean, why are you punishing him this way?
I'm being punished because I have no food now. I have only on social security of $400 I get. And some help from them. My daughter.
Can I say something?
Go ahead.
If he wants to pay, he can stay till the end of the lease. That's what we talked.
Okay. And that's what the problem here is. You can't say I'm terminating his lease because he hasn't paid. If you file a case that says you either have to pay or stay, then fine. But that's not what you filed.
So what did we file?
You filed a case that says you're terminating his lease.
On the ground of non-payment.
The lease doesn't give you, you can't do that. Not with this lease.
It is last 5 months, not a penny has been paid to me.
Okay, so
I did not get a penny from him.
The landlord keeps returning to the strongest factual point he has. No rent was paid for 5 months. And honestly, that is a serious problem. Nobody should pretend 5 months of unpaid rent is minor, especially when the landlord says he depends on that income. But the courtroom problem remains the same. Judge Simpson is not saying the tenant owes nothing. He is saying the landlord chose the wrong legal vehicle. Think of it like showing up to the airport with a train ticket and then getting angry at the gate agent. You may have paid for something, but you are in the wrong system. Simpson even hints that if the correct case had been filed, rental assistance programs might have helped pay the balance. That is the tragedy here. The landlord may have blocked his own best outcome by filing the wrong case.
So here's what's crazy about this. Had you done the right type of case, right? There are programs out there that may have been able to pay the rent.
I would have allowed him. He would have paid to me. But I see that there is no indication from him, though he's working.
Do you hear anything I say?
I can hear again. Please tell me. I'm 83 years old, man. I may not have heard.
But what did I just say? That if you had filed the right type of case, then you could get all this rent paid, get him over this hump, and then let him pay each month. Young man, you told me, why do you think you're here?
I really would think it's because him and my mom.
When did they start going out talking, or whatever you want to put that?
I really don't know. I just came over my mom's house because I haven't talked to her in a while, and she was talking to him, and that was about around the time that the lease got signed. And then a couple months after that, he was leaving voicemail saying, "I can't talk to your mom. Can you contact your mom for me and call her?" And to this day, me and my mom relationship not even good because of him showing up to her house, and to this day our relationship is not good.
All right, let me ask you this. Do you want to stay?
Yeah.
This question changes the direction of the hearing. Judge Simpson asks the tenant whether he wants to stay, and the answer is yes. That matters because now the court has a possible practical solution: preserve the housing, pursue rental assistance, and get the landlord paid. This is where Simpson is not just acting like a referee. He is trying to rescue a messy case from becoming a total loss for everybody. The tenant wants to stay. The landlord says he wants money. Those two goals can actually work together if the case is handled as non-payment. But instead of staying focused, the parties keep dragging the court back into side issues. And that is dangerous, because judges have limited patience when they are trying to help both sides and one side keeps fighting the solution. Would you rather be right emotionally or win practically?
Here's what we're going to do. I could hold a trial, dismiss this case because you don't have a right to necessarily terminate his tenancy. Or what I can do is I can hold my decision, and I'm going to elect to hold my decision and allow you to apply for assistance to get this rent paid.
Sir.
Okay? So, this, yeah, you have a, I couldn't get it out. I just couldn't. It's late on Friday. And I was going to call you something that I probably shouldn't.
I appreciate that. What can I do for you?
I do. Thank you. Can you write down Hawk's number for me? Yeah, you have paper. All right. So here's what I'm going to ask you to do. I'm going to give you housing access for Washington County's number. Okay. Now you're in. Well, hold on. We may have a problem. It may not work for you.
Now Simpson is trying to connect the tenant to housing assistance, but even that is not simple. Jurisdiction, location, county programs, eligibility, these details matter. The judge is basically saying, I might have a path, but let me make sure it actually fits. This is a key retention point because it shows how court is not just about punishment. Sometimes the court is trying to prevent a worse outcome. If assistance works, the landlord may get paid, the tenant may avoid eviction, and everyone leaves with something better than a legal disaster. But the room is still unstable. The landlord and his side keep wanting to introduce more accusations, more frustration, more reasons why the tenant is supposedly wrong. And while that may feel satisfying, it does not help the legal defect. Simpson is trying to build a bridge and they keep setting fire to the wood.
Is it just you in the place?
Well, me and my daughter,
How old's your daughter?
she's 2.
Beautiful. Well, all right. That may work for us.
The daughter is with the mom.
You know what?
His daughter is with the mom, his mom. It's not with him.
No, I have custody of my daughter. It's just my daughter goes to my mom's house time to time.
Can I say something?
But I have papers to show that that's my daughter.
Just one thing. He, he's lying in the court and I can prove it. Number one, he is a caretaker from state of Michigan for his mom, living here, and mom is 120 miles away. One thing.
Okay, so what do you want me to do with that?
He's not.
What do you want me to do with that?
He gets paid.
Help both of them.
He gets paid for that, for taking care of mom. Though he's not doing it, he's there only.
And two, your daughter is not there in the premises. That's another.
You know what I'm gonna do? I'm gonna dismiss this case. You're gonna have to start all over.
We can do that, Judge, but
Oh, I know. I know you can do it.
he is not telling you the truth.
So what right now does that matter? You come here, you tell me that you want the money. And then if you have the money, he can stay. He says he wants to stay. So then I'm figuring out a way to do that. And then you guys, like, whatever, just make a U-turn, start heading in another direction and just want to badmouth.
This is Judge Simpson's patience cracking in real time. He lays out the problem perfectly. 1 minute the landlord wants money, the next minute he wants the tenant gone. Then when Simpson finds a path toward payment, they suddenly pivot into bad-mouthing the tenant. That is courtroom self-sabotage. Judges hate when parties cannot clearly state what remedy they want. Do you want rent? Do you want possession? Do you want termination? Do you want assistance? Pick a lane. The landlord's side keeps swerving across every lane on the legal highway, and Simpson is not having it. This is why consistency matters. If your position changes every time the judge offers a solution, it starts looking less like a legal claim and more like personal anger. At that point, the judge stops seeing a landlord seeking justice and starts seeing a party undermining their own case.
Appreciate it.
So what do you want to do? Do you want the money or not?
If he pays money, he can continue to stay.
You know what? I didn't ask you for that long an answer. That's a yes or no. Do you want the money or not?
Yes.
You want to stay? Okay, this is easy. And man, I'm going to give you, because this is what I would do, just so that we're clear. If they had filed the case right, you would get a number, and I'm going to give you the number. It's 734-961 1999. Okay, and we're going to give that to you on a piece of paper, and that's housing access for Washington County. Now, this address happens to be an 08 address, and let me just find something here just to make sure I give you the right information.
Sir,
Mercy. Yes,
He got $3,700, he told me, for the tax refund, and he never paid anything to me. He said that I'm going to pay out of taxes.
what do you want me to do?
I mean, he wants to pay me taxes.
What do you
which he got
want?
last
What do
month.
you know what? You don't get to work this your way.
He only told me that he's going to pay me the taxes refund, which is he got it.
This is another classic courtroom mistake, trying to relitigate the entire relationship when the judge is already focused on the legal issue. The landlord wants to explain tax refunds, promises, excuses, and broken trust. Those details may explain why he is angry, but they do not fix the filing problem. Judge Simpson has already identified the fatal flaw. This was not filed as the proper non-payment case. So when the landlord keeps pushing the tax refund story, Simpson basically signals, "You do not get to run this hearing your way." That line is important because court procedure is not optional. You cannot drag the judge into every grievance when the legal structure is wrong. And here is the viewer question. At what point does explaining your frustration stop helping your case and start proving that you are too emotionally invested to follow the law?
I'm gonna let you get everything out you want. Go ahead. Tell me everything you want to tell me.
He told me that he's getting 3,700 tax refund, which he will give me. He'll give me all of it. Now that he's not talking about that.
You know what I'm gonna do? Here's what I'm gonna do. I'm not even gonna try to salvage the case. Because you'll be able to get the same thing if they do it right. So I'm just not even gonna hear this. Filed the wrong type of case. This is not you didn't file a non-payment of rent case. Had you filed a non-payment of rent case, he has certain rights that he could assert at that point in time. Could also then have the right to redeem the property prior to being evicted from the property. The case you filed would not give him a right of redemption. I've tried to cut it down the middle so that both parties potentially could be happy. You don't want to do that. So I'm just dismissing the case. You can start over.
I'm asking.
You can start over. You could don't try it with me. I'm done.
This is the ruling moment. Judge Simpson is dismissing the case because the landlord filed the wrong type of action. He even explains that he tried to cut it down the middle so both sides could potentially benefit. The tenant could seek assistance, the landlord could possibly get paid, and the housing situation could be stabilized. But the landlord's side resisted that path, kept arguing, and refused to accept the procedural reality, so Simpson ends it, dismissal. That does not mean the landlord can never pursue the issue again. It means he has to start over and file correctly. That distinction is huge. Dismissal here is not a moral victory for the tenant or a declaration that rent was paid. It is a procedural consequence. The court is saying, your complaint does not match the remedy you are demanding, and I am not going to bend the law to fix it for you.
I'm done. I'm done. I'm done. One more word, you're going. You understand that?
So you will stay without payment. That's what.
Sir, one more word, and you're going to be found in contempt, and you're going to be spending the weekend as my guest. Case dismissed.
This case looked like a simple unpaid rent dispute, but Judge Simpson exposed the real issue underneath. The landlord may have had a valid complaint about missed payments, but he filed the wrong kind of case. Simpson's ruling was to dismiss the case, meaning the landlord would have to start over and use the proper legal process if he wanted to pursue non-payment or possession correctly. The key lesson is sharp. In landlord-tenant court, being frustrated is not enough, being owed money is not enough, and repeating the same complaint louder is definitely not enough. You need the right filing, the right notice, and the right remedy. Judge Simpson also made it clear that he tried to find a practical solution through rental assistance, but once the landlord's side kept pushing contradictions and accusations, the case collapsed. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.